Welcome to the CLAT 2015 analysis of the legal aptitude section. Before we get down to analyzing the different types of questions that were asked in this paper, let us understand the outlay of what CLAT is all about. Now, first of all, we have to know that it is an online centralized test and it is conducting entrance exams for undergraduate courses in law as well as the LLM course. It's a 2-hour exam. It has 200 questions and each question carries 2 marks. There is a negative marking and the question type is of objective. So you are going to be asked MCQs in this paper. Now let us look at the sectional breakup of what all is asked under this paper of CLAT. Now the paper is divided into 5 segments clearly, and legal aptitude section carries a weightage of 50 marks. Then again the general knowledge section carries a weightage of 50 marks. English and the logical reasoning section, they carry a weightage of 40 marks each. And finally mathematics is the subject area with the least weightage as far as marks are concerned. However, I would say if you're good at mathematics, it can go a long way in giving you that short edge of 20 marks. Now, if we only confine ourselves to the syllabus as far as the legal aptitude section is concerned, students, keep in mind that you are only going to be questioned from the substantive aspect of law and you will not be questioned on procedural laws. So, if we look at what are those fields from where you can expect questions they are constitutional law, IPC, Indian Contract Act, law of torts, there's family law, there is jurisprudence, then we have intellectual property rights and other miscellaneous legislations like labor laws, etc. Now, the next slide is talking about the trend that the paper setters have followed right from the inception of CLAT as an examination, that is 2008 was the year when it was conducted for the first time, and till 2015 what has been the trend. So you can see on this slide that in which year which subject was given weightage and how have the trends fluctuated. If we only look at a comparative study between 2014 and 2015, let us carefully look at the slide. IPC in the year 2015, it carried about 14 questions. In 2015, it came down to 9. If you look at torts, there has been a balance, I would say. From 11 in 2014, it came down to a total of 8 questions in 2015. Constitution, we see a complete flip. A huge difference, 1 question in 2014 and 14 questions in 2015. Again, contract, we see a different reversal. 14 gave more weightage to questions on law of contract and 15 minimized it to an extent. Legal miscellaneous section, again, I would say 13 in 2014 and 5 in 2015. So GK eventually was given a lot of importance. It went from 0 to a huge weightage as far as the legal aptitude section is concerned. 0 to 11 questions in 2015. So there have been fluctuating trends, but I can with conviction tell you that these are the areas you are being tested on ever since the onset of these examinations in 2008. Now, what we have to know as far as the legal aptitude section is that it did not carry a lot of surprises like the rest of the sections in CLAT 2015. It was more on expected grounds. If I would give you a very general division, I would say about 30 questions out of 50 were based on the principal fact area and the rest were based on legal facts plus legal awareness. Now, principal fact questions. Principal fact questions, I would say we have picked out an actual question from the 2015 CLAT paper, and let us see how these principal fact questions work. Now, let us read the principle and first identify the subject area this question has been put from. Preparation is not an offence except the preparation of some special offences. Now, the very principle tells us that this question is based on the Indian Penal Code. Let us now take a look at the facts. Ramesh keeps poisoned halwa in his house, wishing to kill Binoy, whom he invited to a party and to whom he wishes to give it. Unknown to Ramesh, his only son takes the halwa and dies. Now, how would you come out with the solution whether in this case Ramesh can be held liable for the death of the child who consumed halwa? Now, if we understand, we have to see whether this offence stopped at the preparation stage or not. So in this case, he kept the poisoned halwa and he had to still administer it to Binoy. Now, his intention stops at the stage of preparation, and that is why the solution also says Ramesh is not liable for murder, since what he did only comes within the category of preparation. Had Binoy actually consumed this halwa, in that case, had he died, it would have been murder. But if he would have survived, then it would have been attempt to murder. Let's take up another principal fact question to get a better clarity. In this case, the principal is saying agreements, the meaning of which is not certain or capable of being made certain, are void. So the fact says a horse was brought for a certain price coupled with a promise to give rupees 500 or more if the horse proved lucky. Now, we are trying to bring out the element of certainty, as the principle tells us, and the fact tells us that 500 rupees more will only be given if the horse proves lucky. So it is a very uncertain, vague or ambiguous term, because there is no standard for us to ascertain how the horse has proved to be lucky or not. So the very solution talks about the same thing, that the agreement is void for the want of certainty, because it's difficult to determine what luck, good or bad, the horse had brought to the buyer. So students, what you have to remember while attempting principal fact questions is that you have to only apply the principle to that given situation. You do not have to think about any other law that you know, any other related aspect of law that you might know. You have to simply apply that very law to that very situation, going ahead with the idea that there is no other law that has to be applied to this situation. This year we saw about 10 assertion reason questions. Now, assertion is when you state a fact and reason consists of a statement which basically gives the cause for that fact. Now, there are 4 ways of attempting assertion reason questions. Before you look at these 4 ways, you have to first understand both the assertion statement and the reason statement. Then you have to see if they both logically connect with each other. Now, what are the ways of looking or attempting these questions? First, you read each one of them individually. Secondly, you see if they complement each other, if reason actually is the cause for the assertion that has been stated. Then you see if both individually, without being a reason for each other, are true, or if either of them are true. So, if we look at the slide, the assertion says idle is a person who can hold property. This is the assertion that is being made. And the reason that they have given for making the statement is only human being can be called a person, not lifeless things. So, idle, of course, is a lifeless thing. So, here they are saying only human beings can be called person. Now in this case, I would say first of all, they do not complement each other. They do not explain each other at all. The reason statement is not explaining to us the assertion statement. So in this case, what we have to now look at is the third thing, whether individually both are true. So if you will take a careful look, individually also both of them are not true, only A is true, and R is false. So that is why you will go with the solution which says A is true but R is false. Another assertion reason question that was asked this time was, it was asserted, in India, every state has a high court in its territory. And reason statement is, the Constitution of India provides for a high court in each state. Now students, of course, this is from the category of constitutional law. What you have to remember is, here your legal fact knowledge will come into play. Now we do know that the Constitution has the provision which talks about a high court in every state. So we immediately know that the reason statement is correct. But now let us look at the assertion statement. In India, every state has a high court in its territory. Is that true? Now we can look at various states which have a common high court, like Punjab and Haryana in Chandigarh has a common high court. So the reason statement is correct and the assertion statement is incorrect, because the first approach is you see or you read these statements carefully, then you see if the reason actually explains the assertion, that is, if they are logically connected with each other. If that does not work out, you individually see if both are correct, and if that does not work out, you see which one is correct, and if that also does not work out, you finally see if both are incorrect and you go with that option. So in this case our solution is A is false but R is true. The next type of question that can be asked is legal GK. Now legal GK, when I say, it involves not just static GK, like they can simply ask you what is Article 14, and it is always going to remain Article 14 is right to equality. Or they might ask you writ jurisdiction is under which article as far as the Supreme Court is concerned. So it will always be Article 32, that will never change. So that is the static GK. But you may also be asked questions on the dynamic GK. Who is the chairman of the Law Commission? That changes from time to time. Then what are the recommendations made by the latest report of the Law Commission? That will change every time a new Law Commission is formulated. So let us look at one of the questions from the legal GK or current affairs section. If you look at the slide, the NDA-led government notified so they have given us a blank to fill, and the National Judicial Appointments Commission Act, thus ending the over 2-decade-old, again they are giving us a blank to fill, of appointing judges of the Supreme Court and High Court. Under the new law, a 6-member panel headed by will select judges of the apex court and state high courts. So you are required to fill all these blanks. Now here your knowledge of current legal GK will come in handy, and this is going to only be possible if you are in the habit of reading newspapers regularly. Now various options were given and various statements were given, and you had to come out with not only the correct order in which these blanks would fit, but you also had to find the right combination. So the solution tells us for the first blank, the answer is 99th Constitutional Amendment Act. For the second blank, the answer is collegiate system. And finally, for the third question mark, the answer is the Chief Justice of India. Another question that we've picked from CLAT 2015, which was from the area of legal GK or current affairs question, was, here again we have been given 3 blanks to fill. Number 1, number 2 and number 3. So let's read the question. The Union government, on the recommendation of the 20th Law Commission, under the chairmanship of Justice A.P. Shah, has decided to decriminalize Section 309. So this question has an overlap of 2 categories. It is not only legal GK but also a question that will test your knowledge on the subject of IPC. Finally, we are going to quote a few straight legal fact questions. Let us read the slide. As per the Indian protocol, who among the following ranks highest in the order of precedence? So this is a question from static legal GK. This is something which will always remain as a fact, and no new event or happening is going to change until and unless there's a change in the protocol, there's an amendment in the constitution in the order of precedence. So the solution gave us these four options: Deputy Prime Minister, former President, Governor of a state within his state, or Speaker of the Lok Sabha. And the answer to this question was Governor of a state within his state. So this is testing you on your knowledge of the subject of constitution. So as far as current legal GK or static legal GK is concerned, it will always overlap with a certain subject field. And finally, the last question that we've quoted is, as far as the legal fact area is concerned, is what is a moot? So the solution carried these four options and we had to choose one: a basic point of law, a basic fact of case, mock court for practice of students, another name for magistrates court. So this is basically about your legal awareness about certain established legal facts, and of course the solution was mock court for the practice for students. So friends, this was our honest attempt to analyze the legal aptitude section of CLAT 2015. In order to perform better at your CLAT exam, I would suggest keep practicing the previous year papers, practice as many mock tests as you can, and try to place yourself under the mentorship of experienced guidance. Please keep writing into us our feedback and queries. We value them a lot, and thank you so much for your time. All the best for CLAT 2016.